I'm going to call this meeting to order. Debbie, can you do the roll call?
Yes, I will. Chris Bird.
Here.
David Connick.
Present.
Alan Sharp.
Present.
Dr. Matthews.
Present.
And William Anderson, who is absent.
How do you think we should? Jennifer suggested that I tell everybody who doesn't know that we're on film.
And you're going to be on YouTube.
Okay.
Thank you, Alex.
Sure.
I'll try to make less of a
Okay.
fool of myself
Okay.
as I'm
I
recording.
want to make sure it registers. Okay.
Got good audio too.
Okay. Old business, I see none. Is that correct? Okay.
Correct.
Adopting the agenda. Are there any changes, suggested, additions, deletions? No.
No.
Is there a motion?
I would move that we adopt the agenda as circulated.
Is there a second?
Second.
Before we do that, I just want to ask, what's this BZA rules of procedure? We did that last time.
Well, there were a couple of members who brought up some points in their,
Yeah, but then
in your
we voted it.
no, this is different. We'll get to that.
Okay.
Okay.
See, this took a month to spread.
It takes us that long to think about things.
I have
Is
an
there-
extra-
there's a second?
Did Chris get one?
Yeah.
I did.
Okay.
All in favor?
Aye.
Aye. Okay. New business. The first applicant is not here.
Correct.
Okay. And he knows about it and he's coming, right?
That's my understanding.
Okay. So I'm going to suggest that we move that to the later and further.
Special use.
Yeah, because we usually don't hear this applicant's not here.
I mean, we discussed it at the at the planning commission, and he was planning to be here, but we did not call him to remind him, so.
And he may not know about the 7:30 thing either.
Okay.
No, we're 7, the planning commission is 7:30.
Okay, that's fine.
Okay, we're okay with that.
I'm okay with that.
Okay. So the next item is variance 160407 Kaitlin. Would you like to come forward? But
May I interject? I met with the applicant this afternoon briefly, and he has driven to Alex to be here this evening to meet with us. And he is considering either asking for this to be tabled or withdrawing the application because he feels that he may need some more time. So I wanted to make you aware of that before you start, because if he does do that, I think he needs to do that before we have the public hearing and the application is heard. So I wanted to make you aware of that before you begin.
well, what are you looking to do?
Well, I've learned some things today. I got down here about 4 o'clock today and learned some things that I'd like to do more homework on, not the least of which is talking to some of my neighbors. I didn't know of their concerns, and I'd rather have a chance to talk to them about their concerns before making a change or completely throwing out my idea. So I wouldn't want to proceed if I can delay this and do it some later time.
So if he withdraws it before the public hearing, then he doesn't have to wait a year?
Correct.
I don't think that's correct at all. I think it says if you withdraw it before the day of the public hearing, so it says.
You have that, can you show that part?
Good.
He researches things.
I don't research that.
Okay, so if that doesn't work, then the next thing would be to table it. That's what.
I just asked Debbie at the beginning of the meeting, and not that this is a major concern, but I put a $400 check down with the variance, and if there's one language that allows me to keep my $400 and one language that loses my $400, at least like to know about
Well,
this.
the basis that we have done in the past is if there's not a full board, then sometimes the applicant will request that it be tabled so that, because otherwise if we get a 2-2 vote,
Sure.
it doesn't pass.
Can I send a letter of thanks to the man that didn't show up tonight? To let him know? Appreciate him missing the meeting. that appropriate or inappropriate?
Well, maybe that would encourage him not to show up. So you want to skip, David, what you're worried about, because he seems to be
I
asking.
request to be tabled
He requests that we consider tabling.
for lack of a forum, a quorum.
We have a quorum.
No, for lack of a full board. Okay.
There's a pleasure of the board. I'm not gonna win that.
So you're not going to make the motion to table?
I'm not going to.
Okay.
Because in all candor and with respect to the applicant, I mean, I think there's some legal issues which we can take up or not take up, but I think, in my opinion, they're dispositive of the application, no matter what comes out of the public hearing. Because it's my view, based on what I have reviewed, that the variance, if the ordinance doesn't allow us to grant a variance where, in a situation like this, where there are two non-conforming lots that were in joint ownership,
That's when it was created.
it doesn't matter when it was created, it matters that they're in joint ownership. And you know, in my view, can't be approved. I mean, we don't have jurisdiction to approve it. So, especially since I gathered from your address on the application and now what they said that you drove all the way down here, I want to make you drive all the way down here
Oh,
again.
no,
If it's going to be dismissed on some kind of technicality like that, but I mean, I'll go along with the board or whatever they want to do.
Well, is it possible to receive an answer about that technicality before I would
Before the
proceed?
next meeting.
Yeah.
Well, I think the board's got to vote, I guess, on it, or I don't know.
We could request a opinion from the county attorney.
Well, the county attorney says he won't give opinions to the Board of Zoning Appeals because he represents the Board of Supervisors, and remember that thing we had about what was it, about something I asked him about a month ago?
Is that Peter?
Peter, yeah.
He's
So
done
we
it
have to
in
get-
the past.
He's done it.
Well, I know he has done it in advance, but that was the last thing I asked him for an opinion on, I can't remember what it was, about a month and a half or 2 months ago. About the payment of the taxes, and he says, I can't give you an opinion without the permission of the Board of Supervisors. He's got to ask the Board of Supervisors, is what he said,
Okay.
if it's okay or not, so the answer is we don't really know.
So why don't we ask the board of supervisors and see if we get an answer? That seems reasonable.
That seems pretty reasonable.
That is reasonable, and so, and I think it is very neighborly that the gentleman came in to see the zoning administrator and then wants to work with the neighbors. Maybe he'll buy some land.
I take that, is that a motion? Or
I'll
somebody
make a
want-
motion that we
Table.
table it until we get a legal opinion from the board supervisor / Peter.
Is there a second?
I'll second that.
Is there any further thoughts? Okay, all in favor?
Aye.
Aye. Opposed?
Abstain.
Abstain, okay.
And one extension.
Okay, well, that was easy. Okay, now the next one is the Chapman family apartment.
Before we do that, we had notice in the paper that there was going to be a public hearing tonight, and with this being tabled, I don't know if you would be required to run that public notice again.
It's tabled, they will.
It's tabled, yeah, so you may want to check back next month, gentlemen, and the
You'll
applicant.
be talking.
Right. So, we won't publish it again in the paper or send another notice, but it would be the same time next month, so you may want to check back.
Yeah. Okay, your timing is perfect.
There.
Okay, you might as well come up here.
Am I late for the party?
Uh-huh.
You're right on. Now, at the BZA, we do swear applicants in, so do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And you're
Robert
Chapman.
Chapman.
And Rappahannock. So you are looking to do a family apartment in an existing structure.
Correct.
In Surrey. You want to tell us a little about it?
Sure, so I purchased the house, the property in 2015, August, and the existing barn accessory structure is about 1,500 square feet. It was built 1873 to 1910, somewhere there. It was always used as a livery stables, where it was used as a dairy barn. It currently has granite floors. There's some foundation, but it is an old structure. So my goal is to pour some slabs, make it a livable space, really bring it up to something a structure that can be continued for the next 100 years. So it's a great old barn. It's got these beautiful, beautiful beams. Kind of want to highlight that character and turn it into a loft living space. Yeah.
And it's 1,083 square feet. Is that what
It is. So, yeah, so on page, this would be page 5. You see the floor plan of the barn. The total square footage is 1,492 square feet. 91. On the right, you'll see a workshop space that does not exist. That space to meet the family apartment ordinance will be turned into a workshop based on the square footage. The rest of the space, the 1,083 square feet, is going to be turned into the family apartment. The two spaces will not be connected internally. They will have exterior entrance and exits. On the family apartment side, there's an existing, and I've called that out, existing door. I will be adding the workshop entrance door. What also is not called out, but you see on page 6, on the reverse side of the barn, I'll be adding another entrance exit. So I'll have 2 entrance and exits from this family efficiency space.
Wow.
And then the end door, you switch to the next, to this one. Then those end doors will become permanently closed.
They will.
Just a facade.
Just the facade. They exist now. I think they're really great. I love being able to park one of my vehicles in there, but I don't want to take them away. I think they have a nice look. They present well from the outside. You can see them from the street, and they look really nice.
So you have the windows now?
I don't have the windows in there. I'll be adding all the fenestration. This is just a concept, whether or not I can achieve all of these windows based on the R values of the property.
Wow.
It's up to Richie.
Okay.
So
Otherwise-
has Richie seen any of this?
I'm doing some work now. He's been in the barn. We talked about it for about an hour. He hasn't seen the concept drawings,
Okay.
but he's doing some permit stuff with pouring concrete and re-shoring up the foundation.
Okay.
Kind of building it out right now. So he's been in the barn and he's a fan of it. He hasn't seen these renderings, so I can't speak to any of that. The envelope of the building is going to be preserved. I'm not adding anything. I'm not taking anything away. Just keeping the envelope of the building intact.
So it's for a family member?
It is. I want this space to be available to my mother. My stepfather's not in the best health. I'm not going to guess publicly on his mortality, but is that, would she be interested in moving to Sperryville in 6 months, 2 years, 5 years? I'm not sure. She's right now living in Texas, so I want this space to be available for my mother to use. In the interim, I'll use it for storage or actually exercise space. I'd like to put in a home gym until she can move in.
So you're not going to rent it out?
No.
For 2 years?
No, yeah,
Okay.
I won't rent it out
Okay.
to anybody but my mother.
Okay. Is there any questions?
What's the primary structure on the property?
Primary structure is my house on the property, you'll see on page 1.
It used to be my grandma's house.
Yeah, highlighted in gray, that is the primary structure. The accessory structure is 13 feet away from the primary structure.
What color is it, yellow?
No,
The main-
it's
the
a
main-
muted
The main
green
one?
gray.
It's very much, main
What's
curve.
this?
Whatever you call it.
So on page 1, the
That's
gray
the other house.
square.
I don't know. Okay. Okay.
Where is it?
It's the gray house that's up on the screen. And
That's
the
the
red
red
is the red one.
No, but I
Doesn't
mean,
have
where
that.
is it?
So if you're Sperry, will go to the corner
You know
store,
where the
take
Methodist
a left,
church is?
it's on your
Well,
left.
show me where the Methodist
Right
church is.
past Pete Estes' place.
Yeah.
Remember the big barn at Pete Estes, and then is there
Across
one
from
more?
Stu Willis.
Yeah, Stu Willis.
Across from there?
Stu Willis is on
It's
the
on the
right.
left
So
hand
it's
side.
right before the church.
Yeah, well, show
Yes.
me, the church is
Correct.
here, and then over here is Reynolds Church, and
Oh,
then
is
here's.
this the church?
Yeah, right,
It is,
this
yeah,
church.
that's the church. Oh, okay.
You're easily confused.
So is that that's his only question?
I don't come to Sperryville in the big easily lost.
Yeah, okay, so now you know what you're talking about.
No, I know what you're talking about.
I'm
Okay,
good.
so it's on sewer.
It's already on sewer, it's already drawn into the plans that are
Right.
at the sewer water.
Okay, so you will get a tap.
An additional ED.
Yeah, okay.
That's doable, I mean, that's possible to do? I mean, they have the capacity to give you another tap?
Yes, I do. That's it. Okay. is
That's
it-
all the questions that I have. I mean, I heard this at the planning commission, so.
Okay, oh, that's right. You were not there.
I was not
I mean,
there.
I'll be glad to report. on
Please,
it.
yes, please.
Well, yeah, this came to the planning commission, it's essentially the same thing, except there was no dumb question like, where is it?
Right.
Exactly, and, because I was not up to speed. And, so it was passed unanimously, and everybody thought it was a good use, and it would be a good thing to do with that building and so forth, so it got the unanimous support of everybody on the planning commission except Mr. Byrne, and I feel certain that had he been there, he would have supported it too.
Very likely.
Because there was no negative comments and there was nothing, there were no, I don't think any neighbors.
Oh,
there was a neighbor,
There was a
yeah.
neighbor that came.
And they
spoke
supported
in
it.
favor, and we have a,
Adolph.
Uh-huh.
She wrote a letter.
Yeah.
Right.
and we have another
Stu
neighbor
even
that,
said he might have
Yeah. Mr. Willis wrote to say that he supported it.
Right, so there wasn't any negative comments, so anyway, it passed unanimous. I mean, it was recommended unanimous.
Okay, since this is a public hearing, is there anybody who wishes to speak on this application? Okay, I'll close the public hearing. Do we have a motion?
I move to approve it.
I'll second it.
Any discussion? All in favor?
Aye.
Aye.
Now, Debbie told me that we're supposed to do every vote as a roll call. Is that correct?
That's my
Our
understanding.
procedures say that. So, Mr.
Well, when we
Bird,
sign the thing, that's,
I know, but it's a roll call. Mr. Bird,
Aye.
Mr. Conlon, David,
yeah, how did I vote? I mean, aye.
I vote aye.
Jennifer, I
Jennifer.
vote aye.
Okay, and Bill Anderson is not here.
Right.
Okay,
He's not going to vote.
so you've got your vote.
Great.
The only thing you should be aware of is under the zoning ordinance, you have to do this and complete it within 1 year of today, I guess, or whenever you get the permit.
We have to complete it or start it?
I think
Start, it has to be,
Start.
and you have
Substantial
to start
start.
construction.
To your
I
plan.
don't remember exactly what it says, but anyway, there's a 1 year.
Substantially start construction.
Or whatever it is, you should be aware of
That's
that.
how I understood.
Yes.
Are you in construction?
Master, what is it, jack of all, master of none kind of thing, so I'm doing a lot of work myself, we poured concrete last week. I would not say I'm in construction, but I make things for a living, and so this is something I'm very interested in.
Okay. Well, you have your permit. Thank you very much.
Thank you very much.
Wait 1 second, I'll tell you exactly what it says, because it's not here.
I just looked it up today.
You did? Okay.
Substantially started.
Okay.
Thank you very much.
Okay, you're welcome, good luck.
Yes, sir.
Okay, now, the next item I asked that we could put on, and mainly, David, this was to accommodate a concern of yours, which is about equal time of speaking.
Equal time speaking.
Well, you had written a, what do you call it? Dissenting opinion. And you did observe in there that you had not been allowed to speak adequately.
Oh, that.
Yeah, and so basically I thought that would be worth bringing it up. And just if there's any thoughts on what is considered a good way to modulate the time that people speak so that everybody feels like they've gotten a chance to speak. But we don't go all night. So, do you have any thoughts on that? Or-
Do I?
Yeah.
My thoughts are it's all covered in Robert's Rules of Order. And I think our procedures now say that we can discuss the thing until somebody calls a question. And that's normally how, if the board votes to terminate the debate, then it's terminated.
So we would need to vote, right?
Well, I mean, I don't know, I have the rules right in front of me right now, but do you have a copy? Do you have a copy here?
Well, I mean, I have this. You want to look at this?
Well, I mean, I look at it, you know.
Okay.
It says one place that, where conduct of the meetings, it says in paragraph I, what I is that, it must be 2I, rules of procedure, 2I1, second paragraph. The BZA shall conduct its deliberations in accordance with Robert's Rules of Order, except as specifically modified by these rules. Motions must be made by a member and seconded by another member in order for them to be considered by the board. A discussion follows any seconded motion, which discussion period may be terminated by a majority vote of the members present.
Okay.
So, I mean,
Okay.
if
that's
somebody, I mean, if somebody thinks that the discussion's going on too long, I guess somebody else can make a motion to terminate the discussion.
Okay, and what I was hoping as chairman was to be able to have some leeway to call the termination of a discussion, or at least,
Well, I don't think you have that authority. I mean, personally.
unless I'm given that authority.
Well, I don't know what the pleasure of the board is, but first of all, I don't think you have that authority, and B, I don't think that the other members of the board have the authority to give you that authority. And the reason is because of the Dillon rule. Because you can't. The Dillon
That's a
rule.
pretty
Oh,
long
come
stretch.
on.
Why is it a long stretch? It's what's in, if you would read.
You mean if we're not given that?
If you're not given the authority to adopt that rule by the state law, you can't adopt that rule. Because, and it's not in the zoning ordinance, and it's not in state law, so the board doesn't have that authority to make up
Okay.
that kind of a rule. And
So-
I mean, personally, I never heard of a rule in any other board or commission that and I've been to quite a few, and served on a number of them, yeah, I have, that where the members, other than what's there, if somebody makes a motion and the motion is seconded and passed to terminate the debate, I mean, read Robert's Rules of Order.
Well, Robert's Rules of Order say that at the beginning of a session, the chair can establish a time, that it's a 2-minute, a 3-minute, a 5-minute point where people can speak from the floor or from.
But I'm not speaking from the floor. I'm a member of the board, and you can.
Or the board member, so the chair.
I don't think it says that in Robert's Rules of Order.
Okay.
You show it to me in Robert's Rules of Order. The chairman can
All
establish.
800.
The chairman can establish well, no, you show me where it says that in there, because I don't think you're right.
Okay, so we could terminate the discussion by a vote.
Of a,
Right.
maybe.
But,
Somebody can make a motion.
but if somebody sort of assumes the floor and won't give it up,
Well, honestly, I don't know about that rule, because I don't think that it's authorized.
What?
The rule I just
What you
read.
just read.
I mean, I don't know who made up these rules. These were the rules that we had when I got here, and I don't know where they came from, but I don't think they're, to the extent that they go beyond.
But that's part of Robert's rules, is that the other members can vote to stop a discussion.
I don't know, I really haven't reviewed it for that. I didn't know this was coming up, so I didn't review it.
Well, I
I mean,
told-
that's-
I
You said
told-
something about it, but I didn't know this is what you were proposing, so
Well,
if you
no,
if you really want to go forward and make a proposal, why don't you write it up and let's debate it next time?
For next time.
And then everybody can have a chance to see what's in
Okay.
Robert's Rules of Order, and it's either there or it's not there.
Okay.
But I think the whole issue is the board, as a board, has the authority
Well, and so what I,
to call, any member has a rule, right, under Robert's Rules, to call for the question.
what I would like to be able to do is to have every member have their say and not have to terminate it before somebody has had a chance to speak.
Well,
So that's,
then don't terminate their, right in the middle of what they're saying. That seems to me to be the way to do it.
and so.
I don't really think it's a problem, but if you do,
Well,
it's up to you.
Well,
I'm happy to hear the views of my fellow board members for however long as they want to go on and talk.
can they do that first?
I don't know, you're the chairman, you recognize somebody, and once you get to the.
Okay, that's fine, okay. I think,
Personally, I would never vote to terminate a debate.
right, no, I understand.
I mean, because, you know, as they used to say on the, what do you call the show there, McLaughlin Group, you know, about Mort Kondracki, every once in a while, Morton would stumble onto the truth.
But it's only when he starts repeating it that it becomes a problem. Okay.
That's a matter of debate.
You abstain. Okay, well, that's enough on that subject. Let's see, what's the other, I guess that's,
The only thing I.
oh, the other question, okay, I'm sorry. The other question was, we have never had a dissenting opinion before like that, and so I'm just interested if there's a procedure for that. And one question that
The written thing that he sent to us via email.
right, and so David, the question that I have about that is, at what point is that dissenting opinion appropriately disseminated throughout the community? Does it go to us first? Or does it just go out?
Well, the board, as I appreciate it, is a sort of a subdivision or a circuit court of Rappahannock County. It's an adjunct of the circuit court of Rappahannock County, and it's appointed by the court, and so it's a quasi-judicial body. And in a quasi-judicial body, all the members have the right to state their opinions, and they can state it orally, or they can put it in writing if they want to, and I chose to put it in writing.
Well, there's been times when Peter Luke counsels that we could only say something in the public hearing, in this forum. And so we had, and I don't remember which one it was, but we were starting to be able to debate back and forth, and he stopped the debate. He said the public is not there, we cannot, the BZA members among themselves, and he said it has to be said at the time of the meeting when once there are more than 3 members that are in a dialogue, be it an email dialogue or a face-to-face dialogue, that would constitute a quorum. And so I had concerns about that, and then some of these
You want me to
other.
answer your concern?
Yeah, go ahead.
Well, I think you're mixing apples and oranges, because what Peter has said, and he said it recently, I guess, to Alex and I, about these emails, that there's, first of all, what you're actually talking about, although you may not be aware of what you're talking about, is the Freedom of Information Act, which says that any board or commission or public body, if 3 or more members have a meeting, there has to be notice, and it has to be in public. They can't have a telephone conference call, they
Right.
can't meet in the telephone booth, and so forth and so on. So there have been a couple of cases involving email communications between members of boards. And I didn't know we were going to discuss this, but I mean, if you want to know what they are, I've got them somewhere, I'll be happy to
No.
send them to you. But I mean, they basically
He
say,
had shared that with
they
us.
basically say that there are two cases in particular, and they both went to the Virginia Supreme Court, and both times the Supreme Court of Virginia said emails are not a meeting. It's not a meeting.
Illegal.
Now, they did say, and they said in this case, and they did sort of leave the door open, and I guess that's what Peter is cautioning about, that if, for example, and this is kind of what they said in the one opinion, if, for example, 4 or 5 members are having a debate by email or texting, they think, and I think the case was decided before Twitter, which I don't use and don't even know how it works exactly, but it's, in other words, they said for it to be a meeting, it has to be simultaneous. There has to be
Like a chat.
like it has to be a chat. Like, for example, if we all got on I don't even know what a chat room is either, frankly, but I think it's a thing where you sign into a group and everybody's typing,
sees it.
and as soon as you're done typing, it goes up and all that stuff. Well, then that, they said, that could be a meeting. They didn't say it was a meeting because that's not what was before them. They said, well, that could be if it's spontaneous and if everybody's there and it's simultaneous. But just trading emails, even between 3 or more members, is not a meeting. And that's the ruling, and that's as far as they've ever gone. So the first answer is, it doesn't implicate the Freedom of Information Act by sending emails to 1 or more members. Now, to the point that's on the table, I guess, is a dissenting opinion. I mean, I wrote a dissenting opinion, and I sent
Where
it
does
to...
it go?
It goes in the minutes.
Now, but where do you deliver it?
I'd already delivered it to the zoning office and said, here, put it on the, attach it to the, append it to the minutes and the decision.
Wasn't it copied to a bunch of different people?
I don't remember who
You said reply all or something.
I
I'm
didn't
just
hit reply
saying.
all. I mean, it doesn't matter. It's a public document, just like the thing we just signed that goes around is a public document. And my dissenting opinion in last month's decision is a public document that is open to everybody. It's not a meeting. It's not a discussion. It's my dissenting opinion. That's me. I didn't discuss. I wasn't debating it with anybody.
Okay, so that's just a question.
My understanding is from legal is that you did provide a dissenting opinion, but the question is, does this board want to make it part of the record? I don't know, maybe David's right, maybe it is a public document, but do you want it to become part of the file? Because as a member of the BCA, you are already putting your opinion on record by giving a vote of yes or no. And in David's dissenting opinion, he was recommending that they appeal the county,
Yeah.
so.
Open to find somebody.
That's not what I said. I said if somebody appealed it, I didn't think it would stand up.
You said you would encourage somebody to.
So, I don't know if that's.
And that
Time's up.
That didn't seem
See,
appropriate.
the thing is that, as you said that during the meeting, one of us, any of us, all of us could have responded to you, but because we don't have that, I mean, I guess we could come back with an opinion against your opinion, or for your opinion, or against it, or
Do whatever you like. All I'm saying is, the reason I wrote it is because I got cut off, like I said, and I wasn't allowed to read those cases into the record and cite them, and the chairman said I'm repeating myself. Well, those cases that go back to 1968 that stand for the same point, so I was reading them into the record. Because I wanted them to be in the record in case anybody appealed the case, that the judge who reviewed it would see that at least somebody on the Board of Zoning Appeals did their homework, read the cases, was aware of what the standards are for granting or not granting a variance and what their decision was based on, not that they just voted no.
I feel that all the members of the Board of Zoning Appeals are very well versed in our chapters and the regulations and what we go by. We have had the luxury of having attorneys on the board, but it is not a requirement to be an attorney to be on the board because they wanted to have the layperson's opinion. They wanted to have a variety of individuals from across the county bringing different perspectives in there. And so, no, I don't go and read the law to find out X or Y or Z. If John McCarthy or if she says, these are recent opinions that have come from, and then they cite that, or sometimes you send that then that's fine, but I cannot go and research that with my job and my other responsibilities. So for you to say, well, if you all are doing your homework and read this stuff, we don't have, I guess online we have access, I guess I have access to LexisNexis online, but I just think that was a little bit over the top.
Well,
Well, so my question is just basically, what would the procedure be? Like, would it be submitted to Debbie, to put in the file?
I've already submitted it, and.
But
it's-
my
yeah,
question is, do you just send it out to everybody?
Do
I
I
think that's
do?
what you did.
You mean everybody on the board?
Just know a bunch of other people too.
Well, I sent it to the planning commission too, yeah.
Okay, and the supervisors.
Mm.
Okay, well, anyway,
I don't think I
so,
did send it to the
so the
supervisor.
point being, from my standpoint, are you going to indirectly be encouraging people to challenge decisions? And will your dissenting opinion be utilized and make it, easy for somebody to challenge an opinion just by saying, oh, here, and then, in other words, you're indirectly soliciting people to challenge the decision.
What was the date of the meeting last month?
Well, that's exactly what I'm getting at. Maybe you should wait until the 30 days are up.
Well, the
Before
30
you-
days I think are up.
But when you disseminate
What
this,
day was in the last month's meeting?
I'll tell you a second.
what I'm saying is when you disseminated this, it was just a few days after the meeting.
27th.
And one of your statements was that you would encourage someone to appeal this decision.
To challenge it, yeah,
Yeah.
because I thought it was a wrong decision.
Okay, but
And
I
that's
don't,
obvious, that
but I
goes without
don't,
saying.
but I don't think that's an appropriate.
Well,
Thank you.
if you don't think it's appropriate, when you write your dissenting
I'm
opinion,
not-
don't say that.
I'm not. Well, I think.
I don't think there's anything wrong with it.
I think it's inappropriate,
Well, okay.
and I'm not sure.
I'll keep that in mind, Mr. Chairman.
Okay,
I don't foresee writing too many more dissenting
Okay.
opinions.
okay.
But, because I don't, hopefully that's not gonna happen again, but I mean, I don't think there's anything inappropriate about it any more than when a court of 3 or 4 judges somebody writes a majority opinion and 3 or 4 other judges on the panel write a dissenting opinion. And if
that's
that,
all delivered at the same time.
Yeah, but
well,
again,
so
you're
what?
not-
If they,
To be a-
can I finish what I was saying?
Yes,
Thank you.
please do.
Because if they write a dissenting opinion, if it's the 4th Circuit Court of Appeals, well, that's an invitation to appeal it to the Supreme Court. If you have 3 or 4 dissenting opinions, that's going to be an indication to the court that you had a dissenting opinion. And whether it says that I invite somebody to appeal it or not appeal it, I mean, I don't know.
Okay,
I think the decision should have been appealed, and I'll tell you why, because that's exactly what I said in the opinion. Because if the judge of this court saw what was done, he never, in my opinion, I don't like to predict what the judge would have do, but in my opinion, from what I know, I don't think the judge would ever have upheld that opinion, that decision. I think it would have been reversed and dismissed, and that's my opinion. So I appreciate that the other member, I mean, I know how you voted, and you didn't agree with what I was saying at the time, and you made findings that I don't think were justified or based on the facts of the case, or the evidence that was submitted to the board. Because the clear, uncontroverted evidence of the applicant and of her builder, 2 people here sat here and said, if we don't have the garage, or if we move the garage, then we don't need a variance.
Okay.
And that was the exact facts in 2 of the cases that were in my dissenting opinion. The exact same facts. The Supreme Court of Virginia reviewed a case, I think one was in Fairfax, and I don't remember where the other one was. It was the exact same facts. And I was in the process of getting ready to read that into the record at the meeting when you told me I was repeating myself and told me to stop talking, so okay,
Well,
so I
okay.
put it in writing and now it's on the record.
So that is part of the reason for discussing, giving everybody their fair time, which was the first part of this discussion. But I will just say, and I don't want to keep laboring over this.
Yeah, you're repeating yourself, Mr. Chairman.
But, well, let me-
You've already said it 3 times.
Okay, what I'm going to say is, I think that it should not be soliciting people to appeal the decision in a dissenting opinion. I think you just make your dissenting opinion. I think it could go to to the proper channels, but I don't think it's just disseminated everywhere. I think as a board member, I think you should not do that. And that's my opinion.
Okay,
Okay?
I hear you.
Okay. Is there anything else on that subject?
I feel that the situation of the Board of Zoning Appeals is a delicate one.
Indeed.
That we are in between basically the zoning administrator and either the courts or the supervisors. And that what I happen to agree with Mr. Connick about that decision.
That one point? Or
That
one
point, and I thought it was a very salient point, and it was something that I felt that a minor design change could have obviated the need for the variance. 3 other people on the board didn't think that. And Mr. Connick and I got outvoted. I do feel that I would not want to encourage particularly non-aggrieved parties to try to further discussion and acrimony in a situation like this. In that particular case, there was nobody who was against the variance. The owners got what they wanted, and so that it was pretty much a non-issue.
Right.
As far as further disagreement was concerned. And all I would say is that to encourage further disagreement and conflict is questionable to me.
Thank you, Mr. Berger.
I'd like to respond to that, if I might.
Please.
Well, I want to respond to 2 points that you made. First of all, I want to thank you for what you said about the subject matter of the decision. I don't look upon the appeal process as like a conflict or any of the adjectives you put on it. Some people may take it that way, and maybe the reason I don't take it that way is because I'm a lawyer. But I mean, I don't mean that as a joke. I mean, that is our process. That is how laws are made. That is how the rules are explicated. That's how, if everybody just said what you just said, well, you know, I don't want to see conflict, and I don't want to see anybody's feelings hurt and all that. It's not, I mean, my vote was not intended to hurt anybody's feelings or generate any conflict, either with the other board members or the people in the neighborhood. My vote is based on my view of the law and what the jurisdiction and the bounds of our jurisdiction on the Board of Zoning Appeals are. It's very limited. We have to make those findings, as one of the cases said. If you can't make the finding on a certain point, the board can go no further. That's the end of the debate. And I think in that particular case, the board deliberately, well, the board I think was well aware of what its limitations are and deliberately made a finding so that they could go further because they wanted to grant the variance. And I think that
Wait,
was...
we said that we wanted to grant the
Can
variance.
I please finish and you can answer me? I didn't interrupt you, Jennifer, when you
Because I
started.
don't talk like you do.
Okay, hold on. Go ahead. Go ahead. Did you forget what you were saying?
I'll tell you what I'm saying. I'm saying you don't know what you are talking about. You've been on this board for 20-some years, and you still don't know the
Okay,
law of
David,
variances.
that's enough.
Well, I'm
Okay,
sorry.
No, stop.
Well, I'm sorry.
No.
You don't know what you're talking about, and you haven't done your homework.
Stop. Okay, the question is you had a vote, and 3 people did not make the same finding that you did.
I'm just saying, I don't think it's inappropriate to invite judicial review of an erroneous decision, because that's how you all find out that what you did, how you voted, was improper and unlawful and violated fundamental principles
And I
of
think-
zoning law. And if someone would challenge it, I don't think the decision would be upheld.
If you were not a board member, I think that would be totally appropriate.
Well, you're entitled to your opinion, Mr.
Yeah,
Chairman.
okay.
Ms. Matthews entitled to her opinion, Mr. Bird's
Okay.
entitled to her opinion, and so is Mr. Anderson. That's not my opinion.
Okay,
I don't share it.
shall we cut the discussion off?
I,
You voted to cut it off.
uh,
Do you second?
yes.
Jennifer?
Yes,
All in favor?
Aye.
Aye, thank you.
I'm going
Okay.
to adjourn.
Well, let me just do one more issue, hold on. The minutes you said we'll just have to do next time? Okay, so we're gonna defer the minutes till next time. Is there a motion to adjourn?
I already made it.
Is there a second?
Done.
All in favor?
Aye.
Thank you.